Good afternoon. As to a mini liquidation on a damages inquiry, at least in a more complex factual situation, the Privy Council has recently denigrated the idea that there should be such a mini liquidation conducted in court in competition with an actual liquidation. That is in the Stichting Shell Pensionen Fund and Crees case, Supplemental 2, tab 31, page 1842, at paragraph 12 on page 1851, per Lord Sumption and Lord Toulson. I will revert to that case later. So we say the analysis should be left to the liquidation proper. How is the court to obtain all the relevant information when a simple balance sheet analysis will not answer? How is the court to convene all the parties if there are other interested parties? The preferred outcome of leaving the matter to the liquidation is achieved by the reflective loss rule applying to creditors. Assume for the sake of argument that a creditor recovers directly from a wrongdoer, either the 40p dividend on my example before lunch, or even in full. That then begs the question of double liability. Three alternative suggestions have been put forward at different stages by the appellants. As the 40p example shows, they must each be capable of operating pro tanto. The first was assignment. Yes, consensual assignment by the creditor to the wrongdoer could perhaps mitigate the problem. But that's not something that is within the court's power to make happen. Non-consensual assignment is subrogation by another name, or otherwise we say a novel legal concept. The second suggestion in the appellant's written case was subrogation. Contractual subrogation is not available. Equitable subrogation is confined to defective transactions, which is not this case.
Need it be? Need it be so confined? If it's an equitable doctrine, is it not capable of extension?
It is currently confined by the decision of this court in Swinson Limited and Loic Rose, which is in the second supplemental authorities bundle, tab 33, page 1870. And as I go through the following principles, I will explain why it would be inappropriate to extend the doctrine of equitable subrogation to this scenario. In the Swinson and Loic Rose case, the relevant passages are Lord Sumption at paragraphs 24, 30 to 31, and 34, and Lord Neuberger at paragraph 117. We say, subject to this court, in today's case, extending the doctrine of equitable subrogation, it is, as the law stands today, wrong to talk of subrogation on our assumed facts because there is no relevant defective transaction. That takes us to the example of my Lord Lord Reid debated with my learned friend, and the rule in Cherry and Boltby, whether one would apply equitable subrogation analysis here or not. So the company has the assets of 9 million and the debt of 5 million. The wrongdoer strips the 9 million. The creditor recovers first in time 5 million from the wrongdoer. The company claims 9 million from the wrongdoer still. Does the wrongdoer have a defence for the 5 million already paid to the creditor? My learned friend's starting point, based on the rule in Cherry and Boltby, is no. If that is right, then the wrongdoer is liable for 14 million, notwithstanding that the assets stripped were 9 million. If the wrongdoer does have a defence, then the company can only recover 4 million. But what has happened there is that the assets of the insolvent estate have been depleted. It had a shows in action for 9 million, and now, by reason of the wrongdoer's 5 million defence, its shows in action against the wrongdoer is only worth 4 million. insofar as the rule in Cherry and Boltby is then taken as a timing point, the starting position, as I say, is that the defendant is liable for $14 million in total, the $5 million already paid and the $9 million now claimed by the company. But it's then said he has the benefit of the creditor's proof for $5 million, which, ex hypothesis, the creditor has not yet withdrawn, notwithstanding it's recovered its $5 million. But unless the insolvency pays out 100p in the pound, then the defendant will still be exposed to a greater liability than the 9 million removed from the company. It's also unclear how equitable subrogation or whatever
Sorry,
other...
just on that, I mean, is that necessarily going to be wrong? I mean, there's a claim that is proceeding, as I understand it in this case, for additional consequential losses going beyond the 5 million debt.
Yes, and that's the 20 from the example given this morning. And the 20 is not reflective loss. So the 20 is never the subject of any double recovery. It's the 50 on the example you gave this morning, which is the subject of the double recovery. So we would say in relation to 20, no, it's not wrong. It's separate and distinct loss. It's within Lord Bingham's Proposition 3. No problems there. But the 50 is where there is this overlap and where one needs some resolution, as the appellants appear to accept, to the triangle as between creditor, company, and wrongdoer. What happens with the proof in this situation? It's not been explained. It's a proof that's been submitted by the creditor in the liquidation. We say on the current law, subrogation would not be available. Subrogation is the only way in which the proof could remain in the name of the original creditor. If one is applying Moule and Garrett, to which we'll come momentarily, then the cross-claim is on that doctrine, which is outside of subrogation, according to Swinson. The cross-claim is in the name of the wrongdoer. The wrongdoer has inured to the benefit of the debt that was previously owed to the creditor by the company. If that's the solution, does it have to put in another proof? But the insolvency is already happening. Has the deadline passed? And so we say that none of these questions have been answered, let alone answered satisfactorily, to resolve the double liability problems that arise in this triangular relationship. The third way in which this has been addressed is in the last fortnight only. It's not in my learned friend's written case, by reliance on the doctrine arising from Moule and Garrett and payments under compulsion. So it's said that if the creditor's damages claim succeeds against the wrongdoer has been compelled at law to pay the creditor, and therefore, by that doctrine in Moule and Garrett, can take the benefit of the creditor's claim against the company, the proof in this case. We have 4 further responses on that. First, it presupposes that payment of damages by the wrongdoer to the creditor discharges pro tanto the company's liability to the creditor, and there's no authority for that. Secondly, the application of the doctrine in Moule and Garrett is not automatic. It is part of the law of unjust enrichment. That is said by Lord Sumption, with whom Lords Newberger, Clark, Carnworth and Hodge agreed in the Angoves Pty Limited and Bailey case, 2016 UKSC 47, at paragraph 16, subparagraph 4, that is referred to, for present purposes, in footnotes 684 and 687 of Chitty, paragraph 29-105, at supplemental 4, tab 10, page 2794. That's the extract from Chitty, my learned friend introduced on Friday. So with the Moule and Garrett doctrine being part of the law of unjust enrichment, there would need to be, in each case, analysis of the four basic questions to decide whether the wrongdoer could step into the shoes of the creditor, even to avoid the need for legal doctrine there. 1, has the company been benefited, enriched? 2, was that at the expense of the wrongdoer? 3, was the enrichment unjust? 4, are there any defences? And those questions would also fall to be assessed, not only in the asset stripper case put forward by the appellant, but also in the negligent bank or advisor case put forward by the intervener. The appellant's earlier submissions that double liability is unobjectionable suggest there would be no easy answer to the restitution questions as between the company and the wrongdoer. Thirdly, what happens if the wrongdoer settles the creditor's claim voluntarily, obviously without the authority of the company? Has there then been pro tanto discharge of the debt under legal compulsion, applying Moule and Garrett? Fourthly, all of this interferes with the orderly channeling of assets and claims through the liquidation in 3 ways. A, there has to be a reckoning as between the company and the creditor in which the latter gives credit for recoveries already made, e.g. by adjusting somehow its proof. So the creditor must either reduce its proof or the proof has to pass over pro tanto to the wrongdoer. B, unless the court's mini-liquidation has perfectly predicted the numbers on the actual liquidation, there can be prejudice to the other creditors because the reflective loss claimant will have over-recovered. It will have obtained a preference. It will have obtained more by way of damages than it would later have obtained in the liquidation if the reflective loss rule had applied. C, the liquidator's claim against the wrongdoer becomes more complex.
Sorry, just on your B, it'll be prejudicial to the other creditors. I thought on this theory, the claimant's right becomes a right on which the wrongdoer can now rely in the liquidation improving. So as against the other creditors, won't that claim be reduced pro tanto so that they don't suffer prejudice?
If you only look at that part of the picture, yes, the creditor is replaced by the wrongdoer, pro tanto. But there are 2 ways that the prejudice to the other creditors can arise. Either because there is a defence on the part of the wrongdoer, so taking the 9 million, 5 million example, instead of the insolvent estate recovering the full 9 million, it only recovers 4 million. That is the most obvious way in which there can be prejudice to the creditors. But if that does not happen because 9 million is recovered, that is obviously mitigated at the cost of double liability, we say. And so on those 2 stark examples, there is either prejudice to the creditors or to the defendant. Lord Millett had this point when he said it's a dilemma. One of those 2 will be prejudiced. And where it is more nuanced is that if the court has undertaken the mini-liquidation by way of damages inquiry and has said to the creditor, we won't give you any more by way of damages than you would have got at the end of the liquidation process, then you are fast-forwarding to a liquidation process. If the court has reached all of the same views on the figures as the liquidator later reaches, then there may be a parity. We concede that much. But we say that that is an unlikely scenario. And what we say is that if the court has been over-generous in its damages inquiry to the creditor claimant, the creditor claimant has one way or another recovered more than it would have recovered in the liquidation, then that will be to the prejudice of the other creditors, unless it's at the expense of the defendant by him being made liable for more than once. So all those problems in relation to double liability arise mutatis mutandis in relation to claims by shareholders if the reflective loss rule is made flexible under issue 2. The second policy justification for the reflective loss rule is causation. This is in our written case at paragraph 18. This applies equally to creditors as to shareholders. It can be tested by the two scenarios I set out before lunch. First, in relation to concurrent claims. If the company is claiming to recover the primary loss, then there's no question of the creditor proving at trial its secondary loss. Any loss to the creditor is temporary only in respect of its reflective loss. We say there isn't circularity here, as has been suggested, because the analysis is a function of the company's loss being the primary loss. Where the company would have made good that primary loss through a claim, its inaction is the effective cause of the secondary loss to the creditor or shareholder. It is the cause of that loss becoming permanent. It may be more accurate, hearing the intervener's submissions, to treat causation here as part of the reasoning or methodology by which the rule satisfies the other policy justifications, rather than a freestanding policy justification in its own right. The second scenario to test on causation relates to creditors claiming first. And there is an open question then of whether the company might claim later. This led to the rhetorical questions of the Court of Appeal in Prudential at page 223F. What happens if the robbery is in year 1, the shareholder sues in year 2, and the company makes up its mind in year 3 to pursue its remedy? Is the shareholder's action stayed, still on foot, supposing judgment has already been recovered by the shareholder and satisfied? What then? Well, we say that is the tip of the iceberg of the problems that I've just set out in relation to double liability particularly. The causation conundrum is closely connected to the question of settlements. For as long as the company is claiming no loss to the creditor, or at least its loss is only temporary, it is artificial to say that upon a partial recovery by the company via a settlement, a permanent loss then crystallizes in favor of the creditor or shareholder in relation to what my learned friend calls the unsettled losses, the 700,000 on his example. Where a company settles a claim that the reflective loss claimant says would have succeeded or should have settled for more, the settlement is the effective cause of the unsettled losses. That is a function of the primary loss being that of the company. That takes us to the third policy justification, the encouragement and integrity of settlements. This is paragraph 19 of our written case. Disapplying the rule to creditors or making it flexible under issue 2 could give the creditor or shareholder a de facto right of veto over any settlement by the company or its liquidator of a claim for the underlying primary loss. The Christensen approach involves the claimant or the court making an allowance of the sum for the sum paid to the company or liquidator when assessing damages on the subsequent claim brought by the shareholders in that case. That's Thomas J. Primary Authorities 2, tab 16, page 1016, lines 42 to 44. So On that hypothesis, when the claim is settled for anything less than 100%, the balance of the claim remains open to be advanced by the creditor or, in Christensen, the shareholder. The main claim there was a claim for $1.1 million for diminution in value of the Christensen shareholding. But that balance of claim, the unsettled losses, remains to be pursued by any creditors or shareholders who are unsatisfied with the settlement by the liquidator.
Well, provided they've got a cause of action.
It has to be that for the reflective loss rule to apply. We accept that. But every creditor or shareholder having a cause of action could continue to pursue either subsequently or sequentially actions against the wrongdoer after the settlement by the company or liquidator. And we say that undermines the principle that liquidation is a class remedy to be conducted in the best interests of the creditors as a whole.
But if you're a creditor with your own cause of action, why does that have to be treated as subject to a class of different people?
Your own cause of action stands separate. If you have suffered separate and distinct loss, you are unimpeded. But if what you're claiming is for reflective loss, and in the settlement scenario, unsettled losses, for as long as the company's claim is progressing, you have nothing to add, because it may succeed for 100% of the primary loss, and your reflective loss goes nowhere. Only at the moment of the settlement can you then say, well, the company has accepted 50% of the claim. I now come in and seek the balance, or together with the other creditors and shareholders, seek the balance of 50%. And that is where we say the impact arrives on the ability of the liquidator to settle the class remedy in respect of that primary loss. The hand on the tiller of the reflective loss creditor claimant means that the liquidator loses control of the class remedy, focusing upon the loss rather than the cause of action. So we do say here again, the argument for applying the reflective loss rule is stronger in relation to creditors than shareholders, or at least it is more pertinent and more commonly likely to arise, since creditors are more likely to have a dividend on the insolvent estate and therefore to be dissatisfied with the level of settlement by a liquidator, and therefore, if the appeal is allowed, to want to push ahead to claim unsettled losses in a subsequent action. Nonetheless, as to shareholders, the point was forcefully made by Mr. Justice Costello in the Irish case of Alico Life International and Thema, Supplemental 2, tab 39, page 2001, at para 114 on page 2030. He said this: if I accepted the plaintiff's submissions were correct, it means that the company, the registered shareholder, and the beneficial shareholders could all sue in respect of the same claim, the total or proportionate share of the net asset value. Each and every unit holder could sue. Not only would it make it virtually impossible, as a matter of practicality, to compromise any action brought by any of the numerous possible plaintiffs, even if the cases proceeded to judgment. If an award less than 100% recovery was made, it would still be open to other plaintiffs to pursue proceedings up until there was full recovery. This clearly would be unjust for a myriad of reasons. The suggestion made to us is that this is all theoretical, and we respond to that with the facts of Coote and Rubin, which is in Supplemental 1, tab 5, page 1231. They're similar to the alleged and assumed facts today, in that between trial and judgment, the company was said to be asset stripped. The majority creditor, a judgment creditor, refused to approve the liquidator's proposed compromise, even where it would garner him a 100% dividend, full recovery of his debt, because he didn't like the fact that 50% of the compromise sum was to be delayed for a year. The court approved the liquidator's compromise in spite of his objections. But if the reflective loss rule was inapplicable, and on the basis that he may have pursued a cause of action such as Marex did, causing loss by unlawful means, I was your imminent judgment creditor and you asset stripped the company, the creditor would, instead of it being a matter for the liquidator and the court, have had the whip hand by dint of his concurrent reflective loss claim. He could have said to the liquidator, well, you settle or not, because if you settle for anything less than 100% immediately, then I'm going to continue.
I mean, it's the same point. If he's got the cause of action, why shouldn't he be allowed to do that?
Because of the extent to which it undermines the liquidator's position. It's the same answer as well. Another example of an aggressive stakeholder is the Prudential case itself. Prudential was only a 3.2% shareholder, but still pushed to a trial lasting over 30 days. So we say that it will become, where these concurrent causes of action exist, difficult for liquidators sensibly to compromise unless the compromise is approved by all the relevant creditors or shareholders who have their own cause of action. We don't accept the intervener's position at paragraph 39C that concurrent claims might cause a wrongdoer to pay more to the liquidator. The wrongdoer values, subject to double liability, the wrongdoer values the claim against it for the primary loss. The logical outcome is that a wrongdoer will not be willing to pay the same amount to compromise the liquidator's claim if there is still going to be a subsequent claim over by the creditor with the cause of action.
Can I ask this? I was thinking about this at level of general principle. If you were dealing with joint and several liability in respect of the same loss, then a payment to one creditor would discharge the debtor's liability vis-à-vis all creditors, and that creditor would then be under a liability to his fellow creditors to share in what he'd received. What we're talking about here is also liability for the same loss. The whole point is it's not separate, and the loss of one person isn't separate and distinct from the loss of another. So at any rate, to the extent of the overlap, we're talking about the same loss. Would there be any analogous principle that I'm just wondering about this double recovery point, you see, that if you were to pay off one creditor, that would in itself discharge the liability towards any other creditors for the same loss?
Well, in principle, subject, we say, to the law of equitable subrogation being extended beyond defective transactions, contrary to Swinson, that is one legal method by which the liability of the wrongdoer or the negligent bank advisor to the company could be reduced. But what that does is it depletes the insolvent estate, because by obtaining that release as against the company through having paid directly the creditor or shareholder on its cause of action, by obtaining that release, the shows in action of the company is reduced. So what has happened is that the insolvent estate has been denuded pro tanto of that shows in action to the benefit of the single creditor or shareholder, subject to getting into the gritty numbers that we were a while ago. But if one looks at it in all or nothing terms, yes, a legal solution could perhaps be arrived at by analogy with other doctrines to achieve that discharge. But that only creates the problem, which comes up against the Stichting Shell case again, as we'll come on to in a moment.
So really, I mean, is the bottom line of your argument that in order to ensure a pari passu distribution, everything has to go through the company?
That is a key justification for the reflective loss rule, exactly so. And that is indeed the fourth policy justification to which we now turn, which is company autonomy and avoiding prejudice to other creditors. And the key point here is the interrelationship between double liability and creditor protection. As Lord Millett recognised at page 62F, there will either be double recovery at the expense of the defendant, or the shareholder or creditor, we say, will recover at the expense of the company and its creditors and other shareholders. And that's the point also made by Besweatherick and McGee in the article you were shown this morning at page 2546. So the solutions avoiding double liability tend to prejudice other creditors and shareholders. Other creditors and shareholders can be protected if there is double liability, but at the defendant's expense. So the only way to preserve the interests of the company and the other creditors and shareholders is either to allow for double liability or to exclude reflective loss claims both by creditor or shareholder, and to give the company and the liquidators precedence in accordance with the pari passu rule and so on. The latter is the correct approach, and that's demonstrated by the Stichting Shell Pension Fund and CRIS case, which I'd like to show you briefly now, supplemental to tab 31, page 1842. The Dutch pension fund had invested in Fairfield Sentry, which was a BVI co, part of Bernard Madoff's fraudulent Ponzi schemes. The fund had obtained a Dutch court order garnishing $71 million in Fairfield's account at the Dublin branch of a Dutch bank. The Privy Council upheld an anti-suit injunction sought by Fairfield's liquidators, restraining those Dutch proceedings. The 3 points to highlight. First, page 1851, paragraph 14. In the BVI, as in England, a winding up order subjects the assets of a company to a statutory trust for their distribution in accordance with the statutory rules. So on the example we were just debating, those assets subject to the statutory trust are depleted by the prior recovery by the creditor or shareholder. Second point, paragraph 24 on page 1856, citing the House of Lords decision in Singularis, which covers the principle of modified universalism, the Privy Council said this: there is a broader public interest in the ability of a court exercising insolvency jurisdiction in the place of the company's incorporation to conduct an orderly winding up of its affairs on a worldwide basis, notwithstanding the territorial limits of its jurisdiction. In protecting its insolvency jurisdiction, to adopt Lord Gough's phrase, the court is not standing on its dignity. It intervenes because the proper distribution of the company's assets depends on its ability to get in those assets so that comparable claims to them may be dealt with fairly in accordance with a set of common rules applying equally to all. There is no jurisdiction other than that of the insolvent's domicile in which that result can be achieved. The alternative is a free-for-all in which the distribution of assets depends on the adventitious location of assets and the race to grab them to the swiftest and the best informed, best resourced or best lawyered. And we say that that race may, if the concurrent claim of a creditor is permitted, be won by the creditor at the expense of the insolvent estate and other creditors and shareholders. Thirdly, at paragraph 40 on page 1862, the Privy Council said, it is in principle inimical to the proper winding up process for a creditor to seek or enforce an order from a foreign court which will result in his enjoying prior access to any part of the insolvent estate. If one tweaks the facts of that case, imagine that Mr. Madoff had moved the $71 million into a personal account and Shell, the pension fund, had a cause of action against him, perhaps causing loss by unlawful means. Should that claim proceed? Or should the recovery of the primary loss be a matter for the liquidators in the BVI, such that Shell could not itself obtain judgment against Mr. Madoff and then seek to enforce against assets, including the assets which he's removed from the company? On the appellant's case, the company's shows of action is not available for distribution after a creditor has acted swiftest and gained prior access in a way that cancels or reduces the company's claim. The same follows if a shareholder is allowed to claim. Marex relies on the distinctions between creditors and shareholders. We say none of them are engaged by the justifications for the reflective loss rule, which I'm addressing. There are naturally some differences, but they may be greater or smaller depending upon the type of investment. They may be practically non-existent in SPVs used for investment purposes. See our written case at paragraph 22. As footnote 39 shows, in structured finance securitization, the junior note at the bottom of the waterfall is referred to as the equity piece, because although it is something held by someone in the position of a creditor, nonetheless, their rights are to what's left at the end of the waterfall, just as if they were a shareholder. My third topic on this issue 1 is alternative remedies, which we say mean there is no injustice in applying the reflective loss rule to creditors. We set out various remedies available to a liquidator at paragraph 27 of our written case. I want to focus now on section 423, which is in our written case, paragraphs 28 to 29. Paragraph 28.3 of the written case has a mistake. The final reference should be to paragraph 29, not 31 of BAT Industries. Also, when you come to look at that case later, my learned friend referred to paragraph 53. That needs to be read in conjunction with paragraph 61 on page 522, where there was further analysis in relation to the extent of requirement for a bilateral or only a unilateral act under section 423. In addition to the written case, I want to emphasize 4 points on section 423. Number 1, it is commonly used by judgment creditors in relation to alleged asset stripping. In addition to the Bataillon and Schoen case at footnote 47 of our written case, that's supplemental 1, tab 3, page 1200, there are judgment creditor cases of Chohan and Sagar at supplemental 1, tab 4, 1222, and Feekins and Defra at supplemental 1, tab 6, 1289. Judgment creditors are perhaps the paradigm for use of section 423, given that its object is to restore assets to the company to make them available for execution. Point 2, the creditor or other victim may bring a section 423 claim before or after insolvency. The only difference is that after insolvency, the leave of the court is required. That's section 4241A. Point 3, the provision can be applied by the English court to foreign companies subject to there being the sufficiently relevant close connection to this jurisdiction. Both the cases footnoted at footnote 48 of our written case involved foreign companies. Orexim, an Indian company. VMZ Red October, a Russian company. Point 4, The wide relief available when the court fashions a remedy can include an order that bypasses the company and orders the transferee to pay sums directly to the creditor. This was emphasised by my Lord Sales in the 4-Eng and Harper case, Supplemental 1, tab 9, page 1359, especially at paragraph 9 on page 1365, where he said this: in an appropriate case, an order might be made to require the transferee to pay sums or transfer property directly to the creditors if the position in relation to execution is clear and any further costs associated with execution ought to be avoided. But often the appropriate order will be for the transferee to pay sums or transfer property back to the transferor, leaving the distribution of those sums or property as between the creditors of the transferor to be governed by the general law. This may be particularly important if the transferor is bankrupt or in liquidation, or about to be, and has a range of creditors, not all of whom are before the court, on the application made under section 423. All of that is sideswiped if a creditor, albeit one with its own cause of action, is able to claim directly in damages for direct recovery from the wrongdoer. As to section 423 and the canoes and cannons example, we accept that it does not cover tarleton, but we say that that is an extreme analogy. One has first to start with the canoes being incorporated, and then it is a case where the relevant assets are destroyed rather than being transferred away. And it may be that if a wrongdoer went into a company and set fire to all the money in the safe, that wouldn't be a section 423 scenario. But section 423 very much can apply to alleged asset stripping at the suit of a judgment creditor. So we rely upon the liquidator's remedies in section 423, and then the interveners enter and say that the liquidator's remedies aren't good enough because they may not be exercised and shareholders and creditors may not get justice. As a threshold point, we observe that the late intervention means there is nobody here, aside perhaps from me, to speak on behalf of IPs and defend their independence. Where otherwise one might have had R3 or the Insolvency Practitioners Association. That would have put all sides of the argument, as the interveners accept is necessary at paragraph 15 of their written submissions. If a trade body for IPs was here, they would probably query the premise. They would probably say there are plenty of liquidators willing to take on a bank where it is appropriate to do so in the circumstances of the case. Otherwise, we make 5 general points in response to the intervener's case. They apply both to issue 1 and issue 2 of the appeal. First, there is a mismatch between the stated problem and the solution proposed today. The intervener's fundamental complaint goes to oversight of IPs. IPs having responsibility for pursuing the claim is said to be at the heart of the problem. At paragraph 22 of Ms. Buchanan's witness statement, Interveners Bundle, tab 4, page 6. Paragraph 29 on page 8 refers to the lack of effective mechanisms to enable business owners to ensure that genuine claims are pursued. That complaint is not met by empowering a concurrent cause of action for reflective loss. The way to meet that complaint would be by revisiting the rules on oversight of IPs. The solutions to that complaint lie in the legislative and regulatory regime governing IPs. This mismatch is exemplified by the fact that disapplying the reflective loss rule to creditors or relaxing it will only make a difference in Ms. Buchanan's scenario C, at paragraph 37 of her witness statement, tab 4, page 11. Only in those cases where the bank has a duty of care to the business owner will there be a workaround to mitigate the problem of lack of IP oversight. Otherwise, in scenarios A and B put forward by Ms. Buchanan, including where the business owner has given a guarantee, this case could not change anything. At paragraph 34 on page 10, Ms. Buchanan concedes that it is not for this court to make specific changes to the insolvency regime. On the APPG's position, that is what is required. If those changes follow to their satisfaction, for example, specifically the Financial Services Tribunal they propose to provide SME owners with cost-effective access to justice against banks is set up. If that follows, any change today for scenario C would only have been a stopgap, albeit with adverse consequences for the reasons I've given that might outlive the introduction of a financial services tribunal unless a later Supreme Court reverted to the Johnson and Gore Wood position. At Supplemental 5, tab 6, page 2866 and following, we have put forward the BIS government response on the government consultation on insolvency and corporate governance. The forward by the Minister for Small Business, Consumers and Corporate Recovery says, we will also make changes to improve our insolvency regime to support companies in financial distress while ensuring appropriate protections for creditors. And there is then question 18 on page 2877, which is about SMEs, showing that reform to the insolvency regime is part of the broader legislative agenda, and no doubt the APPG is lobbying for the changes it says are necessary. Secondly, as to the intervener's case, the case law shows the system operating in accordance with the current statutory principles, albeit obviously with legal costs involved to the business owners. So the first case study of the interveners is the Hocking case. The Hockins were successful in both their application against the administrators and in resisting RBS's strikeout action. On the former, intervener's bundle of authorities 1, tab 3, paragraph 8, the judge noted that assignments by office holders are not unusual. In that case, at paragraphs 50 to 51, the judge said it was reasonable for the administrators not to pursue RBS, given the costs involved, but then ordered the assignment under the unfair harm provision of paragraph 74 of Schedule B1 of the Insolvency Act. The assignment was ordered on terms that 10% of any recoveries plus £5,000 be paid. The judge reasoning, any success if the applicants pursued the claims would be a benefit to the creditors. Conversely, if the claims failed, the creditors would suffer no prejudice. The next decision, which shows the current rules operating, and we say effectively, is the decision of LF2 Limited and Supperstone, Supplemental 5, tab 2, page 2755. It is a pro-assignment of claims decision, viewed overall. At paragraph 65 to 68, on pages 2771 to 2772, Mr. Justice Morgan emphasises that an offer from a potential assignee, for example, a small business owner, shareholder or creditor, is an asset of the company which the administrator should look to preserve and pursue. As to liquidators, it is one thing to state the test of perversity for impugning a liquidator's decision, but it's another to understand how it's applied in practice. 3 cases show additional relevant principles. In the Eden Note case, Intervener's Bundle of Authorities 1, tab 17, page 449, Lord Justice Norse held that a reasonable liquidator is one that is properly advised. The liquidator in that case had not taken advice before assigning the claim to Mr. Venables, and the assignment was set aside, which decision was upheld by the Court of Appeal. Next, the In Re Longmead Limited case. I'd like to show you in Supplemental 5, tab 3, page 2777. At paragraph 52 on page 2788, Mr. Justice Snowden said, liquidation is a class remedy to be conducted in the best interests of the general body of the creditors as a whole. If creditors are not promoting a view based upon their capacity as such, but are doing so as the result of extraneous factors which are not shared by or are even contrary to the remainder of the class, such views should be discounted or not given effect. In that case, the liquidators were to ignore the views of HMRC that they should not pursue a claim against BIS, because HMRC's view was driven by the fact they didn't want claims against the public purse. That was an extraneous consideration. See paragraph 66 to 77. Paragraph 66 in particular on page 2790 shows the established legal principles relating to liquidators commencing proceedings since the legislature changed the position as recently as 2015. So in the context of bank creditors of SMEs, liquidators properly discharging their duties as independent officers of the court should ignore the wishes of a bank not to be sued. The case of Ray Longmead also shows at paragraphs 42 and 56 that the Small Business Enterprise and Employment Act 2015 made changes to facilitate liquidators bringing claims, i.e. they do not now require the leave of the court. The third case is Ultraframe, which is Supplemental 5, tab 5, page 2852. Lady Justice Arden, at paragraph 52 on page 2862, said it was unsatisfactory for a non-lawyer liquidator to value a company's claim. She endorsed in the liquidator context the desirability of the procedure described by Lord Hoffman in Stein and Blake for bankruptcy, namely for the assignment to occur on the basis that a right to a percentage of proceeds is reserved by the insolvent estate. Lady Justice Arden at paragraphs 53 to 54 then focused upon the questions of whether the liquidator had sufficiently investigated the claim and whether it had sufficiently negotiated with the assignee. Pausing there, the appropriate answer to the APPG's complaint, albeit one not available to this court today, would be to relax the rules underlying those cases we've just seen, giving the court yet further abilities to intervene, to supervise the decision-making of IPs, perhaps in tandem with the Financial Tribunal Service, which would be a shortcut. If that were done, the APPG could not then call for any change to the reflective loss rule, we would say. Thirdly, whatever the position on oversight of IPs, there will always be sound policy reasons for the IP taking responsibility for claims. The same policy reasons count against that responsibility being undermined by concurrent claims, all the more so if they can deplete the insolvent estate in the way I described, contrary to the Stichting Shell Authority. Yes, it costs money to bring claims against office holders. And where the complaint is about failure to pursue a third-party bank, yes, it would be understandable that a direct action would be preferable and cheaper for a shareholder or creditor. But we do say that if an SME owner cannot fund a liquidator's claim, then they may be equally unable to fund their own claim. Security for costs may be relevant in both cases, as may stifling and impecuniosity. The solution, again, is a low-cost service such as the Financial Tribunal Service, for which the APPG is lobbying. It is essential to the proper functioning of the insolvency regime that the IPs have responsibility for pursuing claims. They replace the company's directors. That is inherent in the regime. only the IP can take into account the interests of the creditors as a whole, exercising a class remedy. Enabling concurrent reflective claims by creditors or shareholders, we say, will cut across that regime. It will involve a partial transfer of responsibility for the pursuit of claims in respect of a single primary loss to the company against the wrongdoer. These complaints by the interveners also have to be put in the context of the existing law and justifications for the reflective loss rule. The possibility of shareholders or creditors funding claims by the liquidator and the availability of assignments by the liquidator are not policy justifications for the rule as such. They are more reasons cited in individual cases why the Giles and Rind exception has not been made out. Fourthly, the APPG's case on the rule has implications that are not only one way in the triangular relationship between an SME owner, a liquidator, and a bank as major creditor. In Miss Buchanan's scenario C, it will enable the business owner to pursue directly the bank. But there may also be situations where the bank alleges that there was wrongdoing by the business owner, for example, breaches of fiduciary duty as a director. The liquidator may decide against pursuing the business owner. But if the rule is disapplied for creditors, and if the bank has its own cause of action, the bank could, in certain cases, be able to pursue direct claims against the small business owner, even if the liquidator was not willing to do so. Fourthly, insofar as the, fifthly, insofar as the interveners say at paragraph 20 of their submissions that SME owners' loss of control gives rise to a separate and distinct loss, we take no position. Each case will turn on its facts. Lord Bingham's Proposition 3 allows claims for separate and distinct loss that is not reflective, to be claimed. Before leaving issue 1, trustees and guarantors. As to trustees, point 1, this case is not about trustees. Point 2, the Court of Appeal decision in Walker and Stones preceded Johnson and Gorwood and was relied upon therein by Lord Hutton at pages 51D to 51F. Since then, there has been the Shaker and El Badrawi case you were shown this morning. Point 3, there may be a distinction, we say not necessarily to be resolved today, between bare trust cases, in particular where the beneficiary is simply saying it has a beneficial interest in the relevant company shares. That's Walker and Stones, that's Shaker and El Badrawi. Those bare trust cases on the one hand may be distinguished on the other hand from discretionary trust cases, such as the Jersey case of Ansbacher and Freeman at Supplemental 3, tab 44, page 2145. In particular, at paragraph 97, Roman 4 of the decision, Deputy Bailiff Burt recorded that the remedy being sought could involve reimbursement of the underlying company, in that case, SDR. Where that is the remedy, the case is akin to section 423. It is akin to the injunction and specific performance cases, such as Latin American, Supplemental 2, tab 21, page 1704, and the Cayman Islands case you were shown of Gio this morning. They do not offend against the reflective loss rule because they restore assets to the company which has suffered the primary loss. See paragraph 51 of our written case. Point 4 on trustees. The Steinfeld article is predominantly about trusts and the Jeff Cook case. We say it does not engage in detail with the principles that I have just gone through, and at base it is, we endorse an attack on prudential. We say departing from prudential is effectively what the interveners are asking you to do. It would go against the principle of majority rule of a company, subject to the point that they only ask you to depart from it when there is the trigger of insolvency. The Christensen case, which was paid and aid in the intervener's oral submissions, was, I repeat, a claim for 1.1 million in diminution in value of shareholding. So it comes up squarely against the prudential cash box example. As to guarantors, briefly. Point 1, this case is not about guarantors. Point 2, the leading authority is Webster and Sanderson's, that's primary 2, tab 15, page 988, paragraph 54 on page 1004, where the ratio of the Court of Appeal is that the guarantee was covered and therefore losses suffered by the company owner through his guarantee for the company SCYL's indebtedness were barred. And we accept that that is the current state of the law. Point 3, in some cases there may be an argument that a guarantor suffers a separate and distinct loss. And that's what my learned friend was advancing before lunch to some extent. In particular, the implied right to an indemnity in favour of the guarantor against the company only arises post-liquidation. So it will depend upon the facts of the particular case to what extent the guarantor is barred by the rule against reflective loss. Finally, on issue 1, if this court held that the reflective loss rule did not apply to creditors, we say it would be going against the tide of all the courts that have held otherwise on an international platform, even if it is right to acknowledge that many were following Johnson and Gorwood and Gardner and Parker. That's paragraph 33 of our written case. The particular comparative law case to note is Townsend and Genton from the Singapore Court of Appeal. That is supplemental 3, tab 52, page 2333. That was a loan note case. The parent's investment in its 100% subsidiary was originally planned to be by way of share capital, but was restructured to loan capital. Paragraph 74 on page 2333, the Court of Appeal applied Gardner and Parker and held that the reflective loss rule was prima facie applicable. We say that's important because that case is cited by the appellants and in a number of academic articles for saying that the reflective loss rule is really about the unity of interests between shareholder, qua member, and company. But in fact, part of the decision in that case was that it applied to debts. Yes, a shareholder case, but nonetheless a debt case. As to the US position, in response to my learned friend's oral submissions, we also rely upon a number of the US cases in our written case at paragraph 50.3, especially Bagden itself, which is supplemental 2, tab 40, 2032, and the Tooley and Donaldson case, supplemental 3, tab 51, page 2296. You were taken to the Hong Kong case of Veron this morning. That is supplemental 3, tab 53, page 2341. We rely upon it for its application of the reflective loss rule to loan capital. It is therefore a creditor case, we say. A shareholder creditor case, but a creditor case nonetheless. My learned friend made a different point on the facts. He said the holding company should not have been precluded from its claim against its directors, where the subsidiary had no cause of action against the holding company directors. We would accept that. That falls within Lord Bingham's Proposition 2, and the reflective loss rule should not bar that. But that is entirely neutral on the question of whether creditors should or should not be covered. So unless there are any questions, that was what I proposed to say on issue 1, and I'll move on to issue 2. To what extent, if at all...
One question.
Yes.
So far as the 4 policy considerations, which people have agreed apply in this case, are concerned, I appreciate this case isn't about the third party being the trustee or an individual, but the policy reason against double recovery, and certainly the policy reason to protect creditors in insolvency, would apply, would they not, whoever the third party was?
Yes, that is right. If the trustee, notwithstanding a liability contrary to Walker and Stones and Sheikh al-Badrawi, to the beneficiary, remained under a liability to the company, for example, in the scenario where the trustee is also a director of the company and is the party accused of misfeasance, then yes, if I've understood the question, the problem of double liability would remain unless recovery by the beneficiary from the trustee somehow expunges the company's claim against the trustee qua director. Issue 2, to what extent, if at all, is or should the rule be flexible? Here I will cover first, precedent, second, the possibility of no exception, thirdly, jars and rind, and fourthly, any further relaxation. The preliminary observation is that there are 2 very different cases before the court as to what the alternative should be to the status quo. So the appellants say the court should balance the justice between the claimant, defendant and third party, i.e. company, and assess whether refusing to allow the claim is the only way of serving the 4 policy objectives. That's ground of appeal 3, core bundle, tab 1, page 24. In their written case, particularly paragraphs 45.4, 86 and 94, pulling the strands together, they advocate a broad merits-based judgment, cutting and pasting from the Henderson and Henderson rule, so that the rule should only apply where the policies mandate its application. The intervener's case, especially paragraphs 39.2 and 39.6b, is a more bespoke relaxation of the rule, conditional on the wrong being causative of the insolvency, which it was within the scope of the wrong, which insolvency it was within the scope of the wrongdoer's duty to prevent. So we'll assess those 2 alternatives as we go through the following points. First, precedent, paragraphs 35 to 38 of our written case. We say there is a single rule here, we say applicable to shareholders and creditors. And if you relax it, even in our creditor case, then you relax it for shareholders as well. There are 4 points from Johnson to emphasise briefly as to why that relaxation would require, we say, a departure from that decision under the 1966 practice statement. Point 1, the majority were expressly in favour of a bright line rule. That is Lord Millett at 62F, with whom Lord Gough agreed, as I said this morning, at page 41F to G. And Lord Hutton set out his own exposition of the bright line rule at 55F to G. The others implicitly favoured a bright line rule by their strikeout of certain claims on a pleadings basis. Point 2, the claimants in that case had argued for the case management approach. See page 16E. It was argued that the risk of double recovery should be met by case management directions, no doubt in reliance on Christensen. Point 3, it cannot be, and has not been suggested in fairness, that the case was in any way per incuriam. All the relevant authorities relied upon now were before the House of Lords, the pre-Johnson authorities. The 3 articles about prudential relied upon by the appellants were all cited in the Christensen case, which was before the House of Lords. Point 4, when Lord Bingham says some cases will call for a finer judgment at page 36E, that is in the context of determining whether or not a loss is reflective. That is illustrated by the preceding sentence where he juxtaposes 2 clear extremes. He says, on the one hand, you will have loss of dividend, diminution in share value. On the other hand, you will have loss unrelated to business of the company. And in between, cases where finer judgment is called for. What that means is finer judgment as to whether the particular loss is a reflection of a loss suffered by the company. Contrary to the intervener's position, particularly in their written submissions at paragraph 23.2, we say Lord Bingham's strikeout was inconsistent with the Christensen approach to double recovery, namely making an allowance. If that approach was still on limits, there should not have been any strikeout, and Mr. Justice Hart should have found himself making allowances to avoid double recovery as between the settlement of the company's claim and Mr. Johnson's personal claim. My second submission on issue 2 is this. There is support for the view that Giles and Rind is wrongly decided and that there should be no exception to the rule. We have put the material in our written case at paragraph 39, but I don't press that position. That takes us on to the third submission on issue 2, which I do press. There is the existing Giles and Rind exception, which this court should uphold as a bright line exception without trespassing on Johnson.
How narrowly do you construe it? Are you restricting it to a situation where the company's inability to sue the defendant is caused by its by impecuniosity attributable to the defendant's own conduct?
We uphold it. We seek to uphold the position of the Court of Appeal, which is that there is legal impossibility caused by wrongdoer's conduct. And
there wouldn't be enough that a company, for one reason or another, cannot sue him. It has to be the result of his own conduct that it can't sue him.
Yes, that it is legally impossible to do so. For example, the time bar cases are a good way to test that. The Kazakhstan Kagazi and Arab and Kazakhstan Kagazi and Zunas cases are time bar cases where the fact that the company's claims may have become time barred, it wasn't finally decided, is not sufficient to engage the exception because that is not attributable to the wrongdoing. So in paragraphs 40 to 45 of our written case, we set out the 4 reasons why the Giles and Rind position, as clarified by the Court of Appeal, should be upheld. First, at paragraph 41, the Giles and Rind exception is the safety valve that is most consistent with Johnson, especially with Lord Bingham's proposition 2. Wrongdoer caused legal impossibility equates the position with that where the company never had a cause of action in the first place. That is the George Fisher case and the Gerber and Lecture case, where the parent companies were both able to sue for loss of share value because their subsidiaries had no relevant cause of action. Secondly, paragraphs 42 to 43. The impossibility exception does not infringe upon the policy justifications. Thirdly, at paragraph 44, there is the interest of legal certainty, paramount in an area of commercial law such as this. The only current uncertainty in the law, notwithstanding all the academic references, is because this appeal is pending. Otherwise, Johnson and Giles and Rind and the Court of Appeal decision in this case provide a clear and coherent framework for the rule to operate, albeit with a limited safety valve. Fourthly, at paragraph 45, we say an exception should be just that. Where there are the strong policy reasons for the rule that I have adumbrated, the exception should be limited to where it is necessary for the party that has suffered the secondary, the consequential loss to sue instead of the company. The exception of legal possibility mitigates potential injustice, but operates within that appropriate narrow frame. Now, in the context, and again, this is partly my point on precedent, in the context of the burden we say on the appellants to show that Johnson and Gorwood being bright line has led to unjust results, I want to run briefly through the cases since Johnson, with a particular focus on those where judicial concern or disquiet has been expressed. This will illustrate that the law always provides alternative solutions, at least for those properly advised. And insofar as those cases involve liquidators or administrators, I won't repeat my earlier submissions. The first case is Day and Cook, which is Primary Authorities Bundle tab 3, page 566. In that case, there could have been an assignment of the company's claims. See paragraph 10 on page 570. It was wrong to think that would have been champitous. Even if that was a legitimate concern now, it certainly wouldn't be a legitimate concern given the position we know on champity as at 2019. Next, we have Giles and Rind itself. That's Primary 1, tab 5, page 641. The Court of Appeal fashioned the exception, and so there was no injustice. As Lord Millett has said in the Hong Kong Final Court of Appeal case of Waddington, Primary 2, tab 18, 1029 at 1053, there could have been an alternative solution. There could have been an application to the court to direct the receiver to bring the action, to which the discontinuance should not have been an obstacle. That is to say, the discontinuance could have been set aside. Perry against Day, Supplemental 2, tab 25, which is page 1737. Giles and Rind was used to grant relief. The case could have been decided on another basis. It could also have been approached by setting aside the compromise with the wrongdoer on grounds of economic duress, given the finding that it was dishonest of Mr. Day and in breach of the shareholders' agreement to use the mistaken omission of the ransom strip to extract additional monies and his release from liability. See paragraph 3 on page 1740 and paragraph 50 on 1752. If the compromise with Mr. Day had been set aside for economic duress, then relief would have been available to the company in unjust enrichment. In Shaker and Al-Badrawi, Primary 1, tab 12, page 912, a section 423 application could have been brought by the beneficiary qua victim to alleviate any hardship otherwise considered to occur. See paragraph 86 on page 940, as you were shown this morning. The next case in your primary bundles is St Vincent and Robinson, tab 13, page 942. It's not a case where Mr. Justice Mayles expressed any disquiet, but I mention it because he referred to the alternative remedies, a derivative action or a redemption claim that could have been brought in Cyprus. That's paragraphs 99 to 100 at pages 965 to 966. Next we have the two Kazakhstan-Kagazi cases. Kazakhstan-Kagazi and Arip is supplemental 219, page 1672. Kazakhstan and Zunus is supplemental 2, tab 20, page 1639. There was no judicial concern expressed in either of those cases, as the companies were pursuing claims. See paragraph 33 of the former case on page 1683 and paragraph 35 of the latter case on page 1702. In the Latin American Amaro case at supplemental 2, tab 21, 1704, the remedy sought was a restorative one, paragraph 22 on page 1712. It was analogous with the presumptive position under section 423. Peak Hotels at supplemental 4, tab 6, page 2676 is to the same effect. There was no question of injustice where there could be injunctive relief, just as in the Cayman case of Zio. So we say that an appellant coming to this court asking for it to apply the practice statement so as to depart from the bright line rule set out in Johnson and Gore-Wood should have brought a roll call of cases between Johnson and Gore-Wood and 2019 showing there to have been injustice, and there are none. So much for the English cases. One more case is the Scottish case of MacLeod you were shown this morning, primary 1, tab 10, page 859. That case was actually decided per incuriam, in the sense that nobody seems to have appreciated that the reflective loss rule does not bar claims for realised losses on share sales. And that was the factual situation in MacLeod. See paragraph 10 on page 863. We know that they are not barred and they are separate and distinct losses from the Heron case and from item 4 in Johnson and Gore-Wood, the loss of Mr. Johnson's shares, which he had pledged as security for a loan and was not going to recover. And that's summarised helpfully in my learned friend's written case at paragraph 48.4. It's addressed by Lord Bingham at page 37A. On a related point here, my learned friend says shareholders' covenants will become worthless if the reflective loss rule applies to creditors and continues to apply as a bright line. And we say that's wrong. If the company has no cause of action, we're in a Lord Bingham category 2 situation, and the shareholder can proceed to recover the loss even though it's reflective. There is no company cause of action. It's also wrong if the shareholder suffers separate and distinct loss by reason of breach of a shareholder covenant. So by no means do shareholders' covenants or shareholder agreements become worthless. Separate and distinct loss is Lord Bingham Proposition 3. They are only limited where there is a true reflective loss situation. So we say none of the outcomes on the case law in England and in Scotland justify reversing the bright line rule in Johnson. All the appellants can show is that a different view of the law is reasonably arguable.
Can I just check, in Johnson, did the House of Lords assume that the prudential case was rightly decided? In other words, was that a fixed point in their reasoning, and then they proceed from there?
Not aware it was argued
That's
otherwise.
my question. Thank you.
So we say, taking it in stages, we say that departing from Johnson under the practice direction cannot be done just on the basis a different view of the law is arguable as to whether it should be a bright line rule. Departing from prudential is obviously, or overruling prudential is obviously not something that engages the practice statement in this court, but we say cannot be.
Practice statement says, we will normally regard previous authorities of the House of Lords, or of course now the Supreme Court, as authoritative and binding. But we will feel free to depart from where we consider that they are wrong. That's what the practice statement says.
We set out paragraph 10 of our written case.
Oh, you've got plenty of arguments that it's not wrong, and as to what it says, but
we do say in context, it can't be enough simply to decide that it's wrong based on a different view of the law. Chartbrook and Persimmon says that about the practice statement. But beyond that, I rely on paragraph 10 of my written case. So the appellants, we say, have no material to show that the current balance of the law with Johnson and Giles and Rind works in justice. The interveners then plead injustice premised upon cases of which Miss Buchanan fairly indicates this court cannot be given precise details. That's paragraph 38 of the interveners bundle, tab 4, page 12. The answer to the instances she gives of lack of IP proactivity lies, as I've said, in the law and regulation relating to IP oversight. So the problems with a further relaxation of the rule beyond Giles and Rind are addressed at paragraphs 46 to 48 of our written case. Contrary to what my learned friend said this morning, we do say that Gray and Lewis multiplicity could follow if the reflective loss rule is disapplied to creditors and or is relaxed to allow shareholders to bring claims to trial. For example, in the event of a fraudulent circular to shareholders, as discussed in Prudential, every shareholder has a cause of action, and so multiplicity is very much a spectre. The arguments we put forward at paragraphs 46 to 48 of our written case obviously responded to the appellant's position, but we say equivalent problems arise with the intervener's suggested bespoke relaxation. Briefly, point 1, there will be no certainty such that triable issues will invariably arise, in particular as to whether the avoidance of insolvency was within the scope of duty and whether the wrongdoing caused the insolvency. Point 2, the law would be altered with, and particularly the bright line rule, would be altered with implications for the insolvency regime, as I've rehearsed in relation to issue 1. Their case for relaxation is premised upon the causation point, an attack on the causation justification. But it does not meet the problems of double liability, the difficulties in relation to settlement, and the possibilities of creditor and shareholder prejudice we've set out. Point 3, we do say that pre-trial manoeuvres risk becoming labyrinthine as other creditors and shareholders vie for position. If one creditor wins, will another then commence proceedings, assuming they're not time-barred? Having seen the result of the first case, there's no reason that Henderson and Henderson would preclude that.
But I mean, that's just a general issue where lots of people have different causes of action. I mean, that would be true if you're dealing with people with separate causes of action against an individual. They might jockey for position.
Well, it is, yes. And the question is whether, in this context of companies and the competing interests of the creditors, shareholders, any number of creditors or shareholders who have their own cause of action should be allowed to top up by reference to losses that have not been recovered via the first action. My learned friend showed you comparative law that is to some extent pro-relaxation. Our written case at paragraph 49 shows other jurisdictions where the bright line rule has been applied. So for those reasons, we say this court should uphold the status quo, including the limited safety valve of Giles and Rind. Very briefly on the facts, whether the test is legal impossibility or factual impossibility or practical impossibility, it cannot be made good here. And so the decision of the Court of Appeal should be upheld. The only point to emphasise beyond our written case is that this is a situation where Marex has approbated and reprobated in relation to the BVI liquidations of the companies. First, it submitted a proof which was a submission to the jurisdiction as per the Stichting Shell case. See paragraph 56.1 of our written case and Sophie paragraph 17. It submitted to the jurisdiction of the BVI liquidation and the supervisory courts. Secondly, Marex then compromised its costs of the English actions with the liquidator, thereby avoiding detailed assessment of its costs of the proceedings before Mr. Justice Field. That's in the Sophie at paragraph 19. Thereafter, it disengaged from the liquidation. In particular, since the liquidator unsuccessfully resisted Marex garnishing debts due to the companies in the US, it has taken the position that the liquidation is a troublesome irrelevance. There is no reason, we say, why the outcome in the BVI liquidation should be more doubtful than here. No developed case as to why Marex cannot seek justice via the companies in the BVI. It's said that an absence of suit by the companies was part of the plan of the respondent. But the respondent does not control the liquidator. He does not control Mr. Crumpler from KPMG, nor does he have any control over the communications and relationship that could have developed between Marex as a creditor and the liquidator if Marex had not severed that relationship. As to the decision of Mr. Justice Gerber, we accept that that was extremely critical, but it was also critical, except that it was extremely critical of the respondent and the liquidator, but it was also critical of Marex, albeit less seriously so. And we have given the references to that at footnote 79 of our written case. So we do not accept that the possibility of claims by the companies in the BVI was or is merely theoretical. The cases on Giles and Rind, Gardner and Parker, Webster and Sanderson's and others look at the questions of whether the liquidator could be funded to bring a claim or there could be an assignment from the liquidator. The interveners have said, well, that's difficult in some of our SME cases. Marex are not an SME and have never suggested that there is any reason why they could not go down those avenues. So unless there are any questions, that is everything I wish to say.
I think not. Thank you very much indeed, Mr. Lewis.
I should like to start with facts, because the problem with this case, and actually my own friend's submissions, is he detaches his argument from the facts of the case. If the first point is that the companies were not insolvent when the money was stolen from them, and so the counterfactual that you have to ask yourself, well, what would have happened had the money been returned? The counterfactual is companies that are solvent with money here. And had that been the case, we would have had the money under a third-party debt order. So it's as simple as that. The counterfactuals are trying to postulate how life would have been had the companies been in liquidation in July 2013 doesn't arise. They were not. What's more on the facts, two points. May I invite you again to look at Judge Gerber's judgment, this time at page 360 in the bundle. That's core bundle.
Sorry, page 360.
360 in the core bundle. So the findings that are made in conclusion, the court further finds the fact, should it ever become material in proceedings to follow, that Sevilleja and his associates, hence the debtors, were guilty of bad faith in numerous respects, including without limitation, wholly apart from moving 9.5 million in debtor assets out of the UK in the face of an imminent adverse ruling from the English court, attempting, unfortunately successfully, to control a BVI liquidator who was supposed to act as an independent fiduciary by the purse strings, failing to respond to the liquidator's inquiries, depriving the liquidator of the resources he needed to properly do his job, and orchestrating this entire Chapter 15 case to deprive their only non-insider creditor of much or all the fruits of its judgment. Now, that couldn't be more damning as a view of what happened in the present case. But it doesn't quite stop there, because if one turns back to page 218 of this bundle, one can see in a witness statement that was made in proceedings, an early stage in these proceedings, at paragraph 10a towards the end, a description of the amounts of money that had come to the companies from the Refco bankruptcy. So one company got $48 million, the other got $73 million. A goodly amount of money had gone into those companies, which we're told are hopelessly insolvent. And even then it doesn't stop, because at page 219, one can see at 13a, last sentence, the reference to the fact that $1.7 million had been distributed in August 2013, so after the judgments in the present case and before any liquidation. So what you have is a companies which look as though they should have been awash with cash. The cash that was readily accessible to us was removed from the UK. So thereafter, here we are with this BVI liquidation, as to which we can see the learned judge in the bankruptcy court in America taking really very serious views. My learned friend says cheerfully, well, that doesn't matter. We should go off and fight in the BVI and bring proceedings there to put matters right. Well, even for a company, even for Marex, that is money that needs to be spent pursuing something which, after all, has been put up, we submit, as an obstacle precisely to allow the defendant to achieve his goal of making sure that we're unpaid out of the assets that were here. My next point is now on Johnson and Gore Wood. Just to be clear, two things about that case. The first one is paragraph 10 in the schedule of loss, to which I drew your attention this morning, makes it crystal clear that the pension amount was not a debt from the company, because one sees that the concept being that if the money hadn't been paid into the pension, it would have been kept in the company's coffers. And the company's coffers would thereby have had their assets swollen. In other words, there wasn't a debt that needed to be discharged. It was something which, if the companies were able to, out of their surplus funds and up to what was tax efficient, if they were able, they would make distributions. So it's a pure distribution point that in relation to the pension amounts. My learned friend also, and Johnson and Gorwood, conceded, he accepted that realized loss from diminished share value is not reflective. Now, by what rational process is there a distinction between a case where the shareholder still has the shares and they are basically unsaleable, and a case where the shareholder, in the face of a company that's been wronged, is forced to sell his shares, suffer a loss? In the one case it said that's not reflective, in the former case it said that it is reflective. But in both cases, the thing that's brought about the loss is precisely the same, it's injury to the company. So one can see actually in Lord Bingham's speech on the point about the realized loss at page 1589, where the three propositions are set out. At letter G, Lord Bingham referred specifically to Heron International at certain pages and George Fisher, and then Stein and Blake at certain pages. Those pages, the passages that have been picked out in Heron and Stein and Blake, make it crystal clear that realized loss from diminished share value is not reflective. And why is it not reflective? The only answer can be because the shareholder is parted with his shares, so restoration to the company won't actually impact on the shares that the shareholder now has. That's really a rather slight distinction if you're in the position of the creditor who's got, it may be, worthless shares. In the one case you've disposed of them and you've lost your money, in the other case you've still got them and you've lost your money. The next point on to pick out of my learned friend's argument, triangular relationships and double liability, double recovery. He spent a long time trying to explain why it would be quite wrong for a defendant such as his client to be made to pay, on the example of our case, $14 million, being left with a right of proof into the liquidation and into the BVI. Supposing that were the outcome of the proceedings here resulting in a judgment, and supposing further that contrary to the position of Judge Gerber, the BVI liquidation might actually produce an action against him, funded presumably by his colleagues, the puppet companies, the related companies, and he might then be compelled to pay the further amount in the BVI. Suppose that. Rhetorically, I ask, but what's wrong with it? He intentionally caused the injury to my clients, which removed the money from this jurisdiction, which would have been available to them, had he not caused that injury. Frankly, he will have got what he asked for if he is made to pay $14 million. He won't be, of course. He'll only be answerable for the judgment in our action in the present case, because the liquidator is never going to sue him. Moule and Garrett, on this point, my learned friend's argument is slightly odd. May I take your attention to Supplemental Bundle 4, divided 10, page 2794. This is Chitty. Paragraph 29.105 in Chitty has Moule and Garrett, the famous passage set out at the head of the page. Footnote 684, which is straight after in Moule and Garrett, Chief Justice Cockburn approved the following dictum. And one sees at the foot of footnote 684, Lord Sumption specifically approved Moule and Garrett, explicitly justified by the law of unjust enrichment. So Moule and Garrett's been approved. And yet, my learned friend's case is that, in fact, after all, it's been subsequently overruled, without being mentioned, in his 2018 case, which he relies on. It has not been. His argument is that equitable subrogation can't apply other than in defective transactions. Well, that really doesn't stand scrutiny if one considers that Moule and Garrett's not mentioned in the case he relies on. But also,
Sorry, can I just check? I didn't think Moule and Garrett was a subrogation case.
Sorry, my lord is right. It's the discharging the debt and then standing in the shoes of the creditor, and it then goes on to I think subrogation in its pure form, which is the having access to the securities for the principal debt.
So it is
that's where the subrogation part. I mean, I think perhaps we're being slightly confused in using subrogation as, to cover both the proposition of the person who discharged the debt under compulsion, discharging the debt, and then having the ability to be a creditor of the defendant, the principal debtor, but also subrogation strictly is then having access, I think, to the remedies, sorry, the securities and the original debtor had, sorry, the original creditor had. But my submission is quite simple. I rely on the fact that if compelled to pay, Mr. Sevilleja would have the ability to claim in the liquidation the amount of our debt. As to settlements as to the Shell case, Shell's dictum, that one is interesting. One might have imagined in other situations the BVI liquidator actively trying to pursue a case here to stop us suing Mr. Sevilleja, or perhaps himself here suing Mr. Sevilleja. But none of that's happened. It's absolutely dormant in the BVI. And to all intents and purposes, it is possible to ignore the BVI as a real viable place where something might happen relevant to this case. 423, that's in tab supplemental bundle 1, tab 15, page 1504. The point the crucial things to notice about this, the section itself are that in subsection 1 it's transactions entered into by a person with another person, and subsection 3 the person entering into the transaction has to have an intention. It has to be entered into for the purpose of putting assets out of reach. So where, as my learned friend accepted the Tarleton example, where the subject companies don't themselves have such an intention, but they are plundered, section 423 doesn't apply. It's of no help to somebody like my clients.
I'm sorry, could you just make that submission again for me, please?
The point about where the company is simply robbed, section 423 doesn't allow a defrauded creditor to sue the thief. It's as short as that. It only engages where the company has had the intention of putting assets beyond the reach of the victim, the creditor. So one would have to find a transaction, that's say a disposition between the company and, in the present case, Mr. Sevilleja. The company's having the intention to put the monies out of our reach. If Mr. Sevilleja simply takes the money, section 423 doesn't apply. And that was the point also in the BAT case that I referred to this morning.
Last while it's in my mind, Mr. Sevilleja doesn't hold any formal office, I think, in the company. No. But effectively a shadow director.
Perhaps. He got the money. But the point, my learned friend fastens on section 423 as being more or less in every real case the answer, and it's not, sadly. Townsing, the case that he referred to, the Singapore case, the interesting point about Townsing was that the Court of Appeal there did not apply the Johnson and Gorwood rule. They didn't bowl out the claimant. They found that in the particular case, the displacement of the claimant wasn't required. So that case doesn't really help my learned friend. I just like to emphasize, because it may have been confused by me in my address this morning, that I did actually make 5 core propositions. One was that Johnson and Gorwood was narrower than often has been thought. The second was that that accepting that debts might in principle qualify for exclusion, and I don't, but accepting that they might, the company membership was relevant to that question, and that's also reproduced in paragraph in my skeleton my case. The next point was that the pure creditors are outside the scope of the rule anyway because the policy reasons don't apply. The next proposition was that in any event they don't apply to us on the facts of our case. And finally, the Giles and Rind. Now, if it came to it, and this court decided that the Johnson and Gorwood principle could continue without qualification, subject only to Giles and Rind, then I would say that the Giles and Rind exception would cover our case. It should do. But actually, it's quite interesting that my learned friend accepts the Giles and Rind exception should apply, and he puts it forward as an exception, when Lord Millett in the Waddington case in Hong Kong was actually at pains to say that Johnson and Gorwood had laid down bright lines which couldn't be departed from and should not be departed from, and that Giles and Rind was wrong. But essentially what my learned friend's accepting is that there has to be some blurring of the bright line that on his case, Johnson and Gorwood has laid down authoritatively so as not to be capable of being departed from. I think I've now run out of time myself. I apologise if I've gone over.
Seems there are no more questions, Mr. Bumpus. Thank you very much indeed. Thank you. Well, thank you, everybody. I'm not entirely sure why the documents came in this chaotic state to us. Obviously, the late intervention is a separate issue from that, but the authorities are in all sorts of a mess.
Well, may I apologise? I think there have been a number of things that have contributed to this. One, in the first instance, there were some authorities that were incompletely copied, and that had to be repaired. That's, I think, supplemental 4, and that then meant also that references had to be repaired. I think my learned friend had added some authorities and also corrected his references, which came to be supplemental 5, and also dealt with the interveners bundle. So,
well, if I may say, it was a mystery to me why Johnson and Gorwood in the House of Lords wasn't in the primary authorities.
Why it landed up
Absolutely, and in
tab
fact,
18.
I do not physically have it in hard copy.
No, no, do I.
So
I
this
can
is
only apologise for that. I'm very sorry about that.
well, you are on your feet. It is others who will be responsible.
But I get the rocks, I'm
But
afraid.
we don't ordinarily have, in a case involving this sort of sum of money and this sort of expertise of litigators, this sort of chaos in the documents. And I thought it was worthwhile mentioning in that.
And may I then just thank the court for bearing with us so patiently and being so moderate in the comments made.
Of course, it's a great deal easier if you have it on a machine. As it happens, we all do. So, thank you very much indeed. We will now go away and put the wet towels around our heads.